Welcome to the Mentor Podcast, where the most highly motivated entrepreneurs come to get their weekly dose of financial stability with host Ron LeGrand, as well as other nationally recognized thought leaders who will teach you how to get, grow, and protect your wealth.
Well, hello, everybody, and welcome to another edition of the Mentor Podcast. Ron LeGrand here. This podcast is designed to help you make more money and make it faster and pay less taxes and retire rich, and also protect yourself along the way. And frankly, that's one of our guest today is talking about that subject in the form of land trust. His name is Randy Hughes, and he's been around since how long, Randy?
1969, so probably longer than most people that have been alive that are listening to this. Yeah. But not you, Ron.
Yeah, not me, because you know what? I bought my first house in 1969.
You did?
To live in. Yeah, that's a coincidence.
Yeah, it is.
All right, well, we are going to talk about land trust today, and that is a subject that I get endless questions on, as I know you do as well. So you are the expert today, and I'm going to put the load on you to take these questions off of me.
Okay.
So, Randy, first of all, where did you come from? What's your background, and how did you get to be such an expert on land trust?
Well, I live in Illinois, and all my investment property, or most all of it's in Illinois. Started buying houses as an investment. Bought my first rental house, a little 2-bedroom, 800 square foot ranch while I was in college. And pretty much that's what I've done all my life is the house business. I have been in apartments and commercial buildings, but I find that single-family houses fit my personality the best, and so that's kind of why I've stuck with it all these years. And I probably had 10 or 15 houses in my name personally before I woke up to the realization that was pretty dumb, that anybody could look up in the public records what I owned, what the assessment was, what the original debt was that I put on the property, and basically approximate my net worth, which makes me and anybody else that does that a big target for a lawsuit. Right. Unfortunately, the general public's opinion of all real estate investors is that we're all rich, and that makes us an extra big target for frivolous lawsuits. And I'm not talking about avoiding your responsibilities in life. I'm talking about avoiding frivolous lawsuits. And if we have time today, Ron, I'll give a few examples, a few stories of things that have happened to me and have happened to my students over the years that will drive that point home.
Yeah, so your first point is total privacy, so that the predators don't know what you have, so they don't want to get excited about coming after what you have, especially knowing that if you have real estate on public record in your own name, you're an easy target.
Exactly.
And I call it, you have a target on your chest waiting for the arrow to arrive.
Mm-hmm.
So how long have you been using land trust?
Oh, about 40 years now. I've been a landlord for 47 years. And like I said, I was a few years into buying real estate before I realized that I should not be putting my name on these titles. So about 40 years I've been using the trusts and find that they solve a lot of problems and make your life much easier in this real estate investment world.
Okay.
And I just wouldn't own real estate if you made me put my name on the deed. I'd say, Ron, keep your real estate. I don't want it.
Me too, brother. Me too. I will not sign the docs until they get the name on it. And what they always want to do is you buy and I use LLCs for my trustees, and they always want to leave the words "as trustee" off. And that's the very first thing I have to correct. In fact, I'm doing a closing as we sit here, and first thing I look for is, did they add the words LLC as trustee on there? Because if they didn't, that means that LLC owns it instead of just to be the trustee of it.
Yeah.
Okay. Well, you got a lot of reasons. And by the way, listeners, Randy is going to give away a free report with probably 50 different reasons why you should be using LLC's land trust at the end. So just stay tuned and we'll get you the link.
Right.
So let's go over some of these benefits. You're sure not going to go over 50 of them, but go over the ones that are the biggest and most relevant.
Okay. First off, just from an estate planning standpoint, these trusts are wonderful to make you avoid probate after you die, which is a really smart thing to do, because if you own real estate right now in your name and you die tonight, your heirs are not going to get their hands on that real estate for 3 months, 6 months, maybe a year, depending on how long probate is in your state and your county. And they may need immediate control of the property to be able to bury you, if nothing else. So the fact that a trust will allow the transference of control of the property immediately upon your death, to me, is an extremely good benefit.
Right. We don't have enough. We got to get through them because we don't have much time, so we can't dwell on any one.
All right.
What's another one?
Okay. I like the fact that these trusts will allow you to make more money doing the same real estate deals that you're doing now. For example, if you hold the property in the trust, you can sell the beneficial interest in the trust instead of the real estate itself. And consequently, you can avoid the due on sale clause, transfer taxes, sales tax. Now, you don't avoid sales tax totally, but those folks in California, for example, they get the fun of paying 3.3% sales tax on the gross amount of a real estate transaction.
Yeah.
And that's withheld right at closing. And I'm not saying you're never going to pay that, but I'd rather pay it when the tax is due as opposed to right now out of my closing proceeds.
So let's clarify that now, because when you assign your interest to a trust to somebody else, you're not selling real estate, you're selling personal property, which is your interest to a trust. Thus, you avoid the transfer tax.
Right, and that's what's really cool about this trust is when you put your real estate into a trust and you own the beneficial interest, as Ron just said, you own personal property from a legal standpoint. But from a tax standpoint, you still own real estate. The IRS says, hey, these grantor revocable trusts, we don't even want to know anything about them, and just report the tax benefits at the beneficiary level. So you still get the same tax benefits whether you're using a trust or not. And then you get all the benefits of using the trust in addition to those tax benefits.
And folks, you just said two words you need to write down: grantor revocable. We use land trust. It's a grantor revocable trust. Your attorney may understand what you're talking about if you use those two words. We're coming back to this attorney thing. All right, I mentioned privacy because the beneficial interest is nowhere on public record, only the trustee's name. What else?
Well, and to back that up, there's no registry for a trust. There are registries for corporations and LLCs. I can look up
which means nobody can look up
unless it's formed in Wyoming. To my knowledge, that's the only state that does not publish the owners of LLCs. But in every other state, I can look up who owns it. So putting your property in an LLC gives you no privacy of ownership. The other point is, I know most attorneys are telling their clients to put the real estate in an LLC.
Yes,
but if you just think about that just for a minute, I mean, if you have 10, let's say, single-family rental houses, and you dump them all into one LLC, and then you have a loss, a claim, a liability, a lawsuit on one property, and they sue and they win, they're going to get a judgment against the owner. Who's the owner? The LLC. So you just gave them 10 properties instead of one. Yep. So, Grandma and Grandpa taught us all, you don't put all your eggs in one basket, and you don't put all your real estate in one entity. So I teach my students to put each property into a separate trust, so each one is insulated from the other, and then those trusts could all be owned by a single LLC at the beneficiary level.
Yes. So while we're on that subject, many attorneys will tell you to put one property in one LLC, and even in states where they use series LLCs, which means that all of the property LLCs that own a property don't have to file a tax return because they're all owned by one mother LLC or parent entity. But the problem is you still got to pay the annual fee every year just to keep the LLCs alive. And there is no annual fee with land trust, and there is no EIN, there is no tax number, there is no tax return, there's no bank account. And I argue this with real attorneys. Every time I get in front of one and we have this discussion. But by the way, I don't think I've ever won the argument, and I don't think I've ever changed any of them to mine. So good luck trying to do that.
Well, that's kind of a good news, bad news situation too, Ron. They don't teach land trust law to law students while they're in college. They only learn it if they take it upon themselves after college, after law school to learn this. So consequently, 99% of the lawyers in America don't know or understand land trusts.
And they will give you crappy advice.
That's the bad news. That it's hard to find somebody that can give you good, accurate advice. The good news is, once you learn how to do this and create your own land trust, and you can certainly do it on your own, you don't have to have an attorney do it for you. But once you learn how to do it, then you're operating at a level that 99% of the lawyers in the country don't understand. And I think that's a good thing.
You know what I think sometimes, Randy, is that they advise people not to use the land trust because they think that we think, or our students think, that there's some kind of an asset protection device that nobody can penetrate.
Mm-hmm.
And we need to make that clear here. If a lawyer comes after you and they get a judgment and they find out you own beneficial interest in a land trust, they can get it just as they could get it if it was any other entity. But the key is to make sure that they can't get it by understanding how to properly own those land trusts, which frankly could be a whole nother half a day seminar in itself. So let's be clear, a land trust, you get privacy, but as far as asset protection goes, the only thing that it will provide you is privacy so that they don't even know what your assets are. So,
well, and here's the point on that. I can give you a real life personal example of how the first step in asset protection for us real estate investors is privacy of ownership. Because if we're not perceived to be good people to sue, then we're less likely to get sued. I'll give you a good example. In the year 2000, I sold a house that my wife and I and two daughters lived in. 6 months after closing, I got a letter from the buyer's attorney saying that the buyer had to spend a bunch of money replacing an air conditioner and the toilets in the house and some other BS. And if I just sent them a check for $8,000, they wouldn't sue me. Well, what the heck? Who's responsible for maintenance after you sell a house? That's crazy. Right. That is a frivolous lawsuit. So I sent the lawyer a letter back and said, you must have mistaken me for the owner. Did you see my name on the deed? Did you see it on the termite report, the HUD one? Did you see my name on anything? And he wrote back and said, no, I didn't. And if you'll tell us who the owner was, we won't sue you. So I sent him another letter back, and I said, well, I think it was owned by some kind of a trust. They sound pretty complicated to me. I don't really understand how they work, but good luck. And I never got a response.
I love it. Don't you just love it?
Yeah. I mean, they just realized that they were going to have to work for this scam that they were running, and they didn't want to work hard, so they went off and sued somebody who owned real estate in their name instead of trying to find out who owned that trust.
That is correct. Now, we missed one big advantage that I like about land trust, and that is it will avoid lien attachment. In other words, if somebody gets a judgment against me and I own a house in my name, that judgment is going to attach to that house as soon as it's recorded.
That's right.
However, a judgment against me will not attach to an asset I do not own. And listeners, be clear, you do not own the house. The trust owns the house. You own the trust. So even an IRS tax lien won't attach to a property that you do not own. Now, please don't take that to mean that the IRS can't come get your stuff, because they can. Yeah. That's one gorilla I do not want to dance with. Yeah. But anyway, liens aren't going to automatically attach.
Well, okay, Ron, so let me interject something there, because you brought up a great point. Not only is it important not to put your name on a deed, but it's especially important that you don't go on a deed with somebody else. Because here's what could happen to you. 35 years ago, I bought a shopping center with a friend of mine here in town. I insisted on putting the title of the property in a trust. In the year 2000, he moved out of my town in Illinois to Florida and became a very successful real estate developer, made millions of dollars until guess when? Right, 2008.
2008, yeah.
And the collapse happened. He started losing millions of dollars. The last time I talked to him, he said he had $22 million of liens against him. Mm-hmm. Now, about 3 years ago, I'm reading the reports in my town on liens and judgments filed against people in my town. And whose name do I see? My friend. He still lives in Florida. He hasn't lived in Illinois in 15 years, but a bank in Florida is filing a lien in Illinois trying to find assets in his name. A $3.2 million lien was filed in my county. If I had not insisted on putting that title of that real estate in a trust, and he and I had gone on that deed together, I would have just been wiped out. That 35
so simple,
years of investment and work and cash flow and appreciation, all gone because of something he did.
So simple, huh?
Don't ever go on a deed with somebody.
Okay, so I know you get, well, first, let me knock out one. Yeah, I hear constantly, my attorney said there's no statute concerning this trust, so it won't work here.
All right, let's address that. Most states don't have a land trust statute. There are only 6 or 7 that really have an actual statute. And I personally think it's a good idea to set your trust up in a state that has a statute, no matter where you live, no matter where the property is. But you don't necessarily have to follow that advice. You know, if you're in California, for example, they don't have a statute, a specific land trust statute, but they're legal to use in California, and they're legal to use in all the states. It's just that I think some states have better laws than others, and that's why I want to form my trust in a state that has the best law, in my opinion. Right. But they are legal in all. And if an attorney tells you they're not legal, then find another attorney because he doesn't know what he's talking about.
Well, that is correct. And if he tells you land trusts don't work here, also find another attorney. Or use the words grantor revocable, and maybe he will get it. And by the way, you live in the first state that started using these things in the United States, Illinois.
That's right.
It used to be called Illinois Land Trust. Do you happen to know how far back these things go when they first started?
A little over 100 years. The very first land trust in America was formed by Chicago Title in a suburb of Chicago that was being developed about 15, 20 years ago. So Chicago Title is the mother lode of land trust. They actually they have a title, a trust department. Chicago Title does, but they'll only be trustee in 2 states, and that's Illinois and I think Indiana. But they manage over 65,000 land trusts. So they're the big gorilla. But it's the reason why I mention that is it exemplifies the fact that these are legal. They're used all over the United States. I get people saying, well, gosh, is my trustee going to steal my property? Well, no, that's not going to happen. If it was that easy, these trusts wouldn't have been around as long as they have. And they've actually been around for a couple thousand years in England, where we got our laws cheated over to the United States.
They actually go back to the Roman Empire.
Yeah, they go way back.
Yeah. So there are many states that do not have statutes, but that does not mean that they don't work just because there's no statute on it. In fact, it'd have to be a statute that says they don't work for them not to work. So, Randy, I get this question all the time. Well, how do I form a trust?
Well, all you really need is the training and the knowledge and the forms, and you can form a trust. And as I mentioned earlier, each state has their own laws. There's no federal land trust law. That's all state by state. So what really confuses the lawyers is when I tell them that I could form a Florida land trust to hold title to my property in Illinois. And most of them say, well, you can't do that because that's their natural response to pretty much anything they don't understand. But you can, and I've done it for 35, 40 years.
Have you ever been challenged on it?
Not all the way in court, but that's the whole idea is to put together a structure that people don't want to challenge. But I'm sure that other folks have been challenged. Have you?
Nope.
Well, then I think that's a good thing.
I've been taking
to show you that it works.
Since 1982. And there's never been any challenge, but I can tell you there's been a whole lot of challenges trying to get people to understand what the heck I'm doing. you gotta. And by the way, that's a point. Don't try to train the people that you're working with on what a trust is. Just tell them what you want them to do. They're supposed to do what you tell them to do. I use a warranty deed to trustee. I put it in my attorney's hands, and if he don't like it, he can fix it. But that's the deed that puts the property into the trust and actually establishes the trust. And then the only other document really is the trust agreement, which sits at home in your filing cabinet. So it's really not a big deal to form a trust. The minute the deed is recorded, the trust is formed. So do you have any other documents that's part of this other than the agreement and the deed that you like?
Oh, no, not to create the trust. My other forms are just, administrative forms. Like if you want to change the beneficiary, you want to fire the trustee, you want to hire a director. I've got administrative forms, but you're right. All you need to do to form that trust is have a deed and a trust agreement. Now, oftentimes, Ron, I get people say, well, I can get a trust agreement off the internet. And that's true. You can. You can get a 1 or 2 pager and you get what you pay for. I think the trust agreement is the heart of the trust and everything that's going on here. I just finished my 6.0 version of my trust agreement. It's 40 pages. And I want it to have teeth, and I want it to have substance in case it ever does get challenged. It's not going to be a 2-page pushover.
Right. Okay. So, gosh, I had a really important question right on the tip of my tongue, Randy, and I lost it just like
we
that.
We could probably talk all day about reasons to use these trusts.
Right.
And I think it is important to tell people, that, especially real estate investors, that they can create these trusts themselves.
Yeah.
It doesn't
in 10
take
minutes.
a genius.
Yeah. Yeah. By the way, can the lender call a loan due if I put my house in a trust?
Well, I guess the first answer to that question is, are we talking about a personal residence or an investment property? If it's a personal residence, no, they can't call it due. Every American has the right to put their property into a trust and not trigger the due on sale clause. And that was due to the law passed way back in the 80s called the Garn-St. Germain Act. Mm-hmm. Now, if it's a commercial property, technically they might have the right to call the loan due if they find out. And I tell my students, you got 2 decisions. One is you can tell them, and 2 is you don't. Now, I don't deal with big national banks like Bank of America and Chase and all those guys. They got rules I don't like. I deal with regional hometown banks. And my experience has been, I've just gone to those banks and said, hey, I'm doing some estate planning for my family. You mind if I put the property in trust? And every one of them has said, no, go ahead and do it. It's fine with us. And they put that in writing to me that it was okay to do that. But if you've got a loan that's a conventional loan that was sold in the secondary market, technically, if they found out that you transferred into a trust, they could call the loan due. But my experience is 99.9% of the time, they either don't find out about it or don't do anything about it and don't call the loan due. It's not really been a big problem for me and my students.
Well, first of all, bank ain't going to call a loan due anyway if somebody's making payments. But actually, I think you do have the right. In fact, I'm almost positive you have the right to put your rental properties into a trust, and they cannot call it due because it is part of your estate. And Garn-St. Germain prohibits them from doing so, and they know it, and they're not going to. I've seen many letters. Students go home and they ask the bank. Bank sends them back a letter saying, yeah, and they cite Garn-St. Germain. But as far as commercial properties go, I would buy those in an LLC, one property, one LLC. Because, if I were to ever go get a loan on that property, the loan would be to the LLC and not to me personally, even though you may have to personally guarantee it. Right. But the LLC, I mean, that's a business. That's a business that requires a tax return and requires an annual reporting and all of that stuff. So if that's the case, LLCs are easy for people to understand and operate in our society. So I use LLCs for every commercial property that I've ever had. One LLC, one property. But it's your choice. But in fact, I'm taking title to a piece of land in a couple of days. I will be taking title to it in a land trust. But there's no income producing asset there, so I wouldn't use an LLC.
Well,
right.
let's clarify it, Ron, that because a lot of people think that only land will go into a land trust because of that word land as kind of a misnomer. And so I want the listeners to understand you can put any kind of real estate in a land trust, whether it's commercial, residential, air rights, mineral rights, contracts, options. It's funny, I had a guy call me last year and he said, I want to get your home study course and learn how to create land trusts. And I said, great, what are you going to do with it? He said, well, I'm down here in Kentucky. I've got 1,500 oil and gas leases, and I don't want to put them all in one entity because some go boom and some go bust. So he got my home study course and created 1,500 land trusts. So each one was separate from the other. And, certainly you couldn't afford to hire somebody to do that. So he did it all on his own. But the point is you can put any kind of real estate into a land trust.
All right, I got a question for you. I got a land trust, and of course I'm the beneficiary or whoever I choose. What's stopping me if I wanted to sell that property with owner financing, to sell the beneficial interest and just create a non-real estate agreement to pay that back, which means I could actually take it back a lot faster. If it's personal property, then I could if it's real property, because it doesn't come under real estate rules. You understand what I just said?
I do. It's one of the techniques I teach my students, and I've used it many times myself. Basically, what we're saying is that it's kind of like buying a car. If you buy a car and finance it at the bank's going to keep the title to that car until you make the very last payment.
Right.
And if you don't make the very last payment, they're going to come repossess the car. And that's a personal property interest in that car. And that's what you just mentioned, Ron, is when you sell the beneficial interest in a land trust on an installment contract, you're selling personal property from a legal standpoint. And so if the buyer defaults, we repossess, we do not foreclose. And I hope your listeners are catching that, because that concept by itself that you just brought up, Ron, was worth listening to this entire call.
Yes, it was.
It's a great way to make money in this business is you be the bank. You buy low, you buy these houses low, you sell them high to people who can't qualify for a loan. And there are a whole bunch of really good people in America that can't qualify for a conventional loan.
Yep.
And so you be the bank and you sell it to them on a contract at full retail, 7 or 8% on the contract. So you're making great return on your equity. It's just all around a great way to make money. But the big risk there is what the banks have, and that is what happens if the buyer stops making payments. And in this example, the buyer stops making payments, we can get him out in about 30 days, as opposed to 6 months to a year, is how long it takes in Illinois anyway to do a foreclosure.
That will depend on what state you're in.
Right.
And you would most certainly have to have a lawyer tell you what would be involved in taking that personal property back, and a special document for your state to do it. So you wouldn't be an idiot to try to do this without a lawyer. Plus, the lawyer needs to be in front of the buyer to explain everything to them, so they can't come back and say, I didn't understand that I really didn't own the property, I only owned the trust. But we also avoid closing costs other than that lawyer fee.
Exactly. And then speaking of that, these closings I have, Ron, I do at my lawyer's office in his big fancy conference room. And so I've got everybody's testimony that, yes, the contract was explained, and my attorney explained it to him. If they don't have an attorney there to explain it to him, my attorney explains it to him. It's all official. Everything's notarized. My attorney serves as an escrow agent that holds the documents in case something happens to me. They can still come and get the beneficial interest once they pay the note off. But it's all done officially, so everybody understands this is an actual closing of the purchase of.
Right. And you'd probably still keep the insurance, your policy on there as a non-owner occupied policy, wouldn't you?
Well, actually, I require them to buy homeowners insurance. And I've got my trustee listed as an additional insured, so we're notified if they don't make payments. But I don't want just renter's insurance. I want full homeowners coverage on there, and they're the named insured, and we are additional insureds.
But they don't own it. So how's the insurance company going to issue them a homeowner's policy?
Well, because by contract they are buying it from a tax standpoint. It's back to that bifurcation of what's going on here, where from a tax standpoint they own it, but from a legal standpoint they don't. So far, I haven't had any problem with insurance companies giving them a full homeowner's policy.
Well, that's probably because the insurance company don't have a clue what you just did, Randy.
Well, it could be, but as long as it's
I'd worry about that one.
Well,
you know what?
They're on the hook.
Yeah. Well, all right. So anyway, is there any last advice you could give our listeners? Because we're already a little over time. We still got to give away your free thing yet. Yeah,
well, I'd just say get the free thing because it's got a lot more reasons. And if you got any questions, my email is in that booklet. I don't know if you want me to give out a phone number or website or anything, Ron, but
we're going to give out the website right now. It's called thementorpodcast.com, thementorpodcast.com/land trust. That's simple. There you'll find his free thing and a bunch of our free things and my free book and video. And in fact, you'll find a whole lot of stuff that's been posted and a whole lot of past podcasts that have been posted. So just go there, and while you're there, make sure you sign up as a subscriber now, so you get notified of these things. They're played every Wednesday, so there's plenty of stuff there for you to go to. I'm going to tell you, when you get Randy's free report, you're going to get information about his land trust course, because it's the best that I've ever seen. I'm sitting here looking at it right in front of me, and I've been doing land trust for, I don't know, 37 years, and I learned some things in there that I didn't know all of these years. So, and it's inexpensive. So, thank you, sir, for taking the time to spend with us today. I'm on a subject that there needs to be a lot more education out there on than there is, but I guess it's up to you and me, huh?
Yeah, that's our job, Ron.
Okay.
Well, thank you much for the opportunity. I hope everybody got some great ideas out of this conversation, and I'll just leave it at this. Don't own real estate in your name, please.
And I'll leave it at this. Don't own anything in your name.
Good point.
This is just the beginning. There are other types of trust too, but it's enough for today.
Right.
All right, guys. Thanks for tuning in. Appreciate you coming, and thank you, Mr. Hughes. See you all later.
Thank you, Ron. Bye-bye.
That's all for this edition of the Mentor Podcast. To connect with Ron and learn how you can attain financial freedom, as well as up-to-date strategies to grow and protect your wealth based on today's discussion, go to www.connectwiththementor.com.